not live from your computer. It's AP Gov. Here we are with Unit 3, doing a little bit of 3.1, the Bill of Rights today, and a little bit of 3.2 with freedom of religion. Now, this is basically the same information you will get from the AP videos. They explain it one way. I explain the information a way that you're used to me explaining things. So if you'd rather go the route of the AP videos, go for it. But here is an alternate resource for you guys. So 3.1, all about the Bill of Rights. And we spoke a lot about that already this week when we looked at the multiple choice questions. And we already know a little bit of foundation as to why the Bill of Rights was written and the debate between the Federalists and anti-federalists, if that Bill of Rights was even necessary. Now, I also mentioned that there's some disagreement between me and the AP report that the father of the Bill of Rights is James Madison, and I'm a huge Jemmy Madison fan, okay? But do we even need to like label something as a father? Aren't there multi-fathers? It's there's different types of parental units, right? I would argue that you need to consider George Mason, even though he left the convention to the displeasure of George Washington. But why? Because he was not happy that there was no Bill of Rights, and he helped Virginia with their Bill of Rights. He knew how important it was. We mentioned some quotes of George Mason as to why he thought a Bill of Rights was so important. So let's look at some quotes from Madison. We've gone over some Madison quotes already with the Federalist Papers. You know, if all men were angels, no government would be necessary. Sort of similar to this quote. You see how it ties in. That the essence of government is power, and power lodged as it must be in human hands will ever be liable to abuse. Now, that's why there's checks and balances in our Constitution, right? And he thought that would help protect the rights of the people. But how do we ensure that those people have rights that cannot be abused, right? The underlying principle of the Bill of Rights is that these rights are fundamental. So we have liberty versus order. The other Madison line about heirs to fire, right? About liberty. You remember that? Go back and look at that one. All right. Liberty is great, but if you have too much of it and it's not controlled, it can get a little crazy. So how do you corral that? How do you gear that to just productivity? So you had the Articles of Confederation, which did allow for large amounts of liberty. All right, that's good. But the order wasn't so great. There were problems. There were 99 problems. There were probably more. If we had to list 99 problems from the Articles of Confederation, I bet we could do it. Do you want to do it? We can do it. All right. So it was a weak government. They needed something different. They needed something with a stronger federal government. And what did they come up with? You know it. They came up with the Constitution. All right. The Constitution was stronger. So you're going from more of a weak government to a strong federal government. Now, eventually, as we know, we add the Bill of Rights. Okay, that was Madison's like way of appeasing the people, right? I'm not sure he didn't. He's like, he didn't even want this Bill of Rights to begin with, people. That's why if you didn't even want it, you can't be called the father. A real father wants their children, and therefore he cannot be the father of the Bill of Rights. But he eventually turned around and said, yes, I now want this child. Okay, I now want this child because it will make other people happy. And if other people are happy, then this family will continue to grow and be strong. So the Bill of Rights were clarifications, right? Let's sort of clarify some of these things. Now, if you look at the Bill of Rights, the amendments 1 through 8, it's basically like holding up a mirror to what just happened and saying, all right, how do we make sure that doesn't happen? So what are the things that the king did that abused his power, that abused the liberty and rights of the people to make sure it doesn't happen again? For example, right, like we learned about not quarantining, quartering, right? We don't really hear quartering these days, right? Well, it's because we have the Bill of Rights. They can't do it, right? But like, why was quartering such an issue? Quartering in the French and Indian / 7 Years' War, right? Quartering in the in the revolution. And it wasn't so much that they were upset that people were in their homes. More often than not, they weren't in homes. They were in like hospitals or warehouses. It's that they were mixing with our people. Our daughters were marrying them, right? Oh my gosh. So that's why the 1 through 8 is a direct rebuttal, a direct defense from the things that kings did that were wrong. Then we have 9 and 10. 9 and 10 are a little bit different. 9, there's something called the Penumbra Doctrine. You don't really hear people talk about that word much, but basically there's a lot of gray areas. Okay? Congress writes legislation and they write it broadly. And in those gray areas, things exist as well. For example, a right to privacy, something we mentioned with Roe v. Wade. What amendment says right to privacy? Right? Nowhere does it say right to privacy, but it's implied in a few different things, in the first one, in the 14th one, things like that. All right. Now, the 10th Amendment, this is also sort of making the anti-federalists happy as well. Okay, because remember, they still want states' rights. So any powers that aren't here and they're not prohibited, they go to the states. The states have those powers. Or the people, right? The we the people, fuzzy part of the Constitution, didn't come until the Bill of Rights, remember. The we the people isn't really this is the we the people down here. All right? Okay, now let's move on a little bit to part of the First Amendment. The First Amendment includes so many things, but even the freedom of religion breaks down into more things. So it says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So there's 2 parts. There's 2 parts to the freedom of religion, people. Put a little line here, all right? And that's where you get the Establishment Clause and the Free Exercise Clause. So there's 2 parts. So let's first look at the Establishment Clause, all right? Establishment. So think no established religion. The Establishment Clause prevents establishment of an official government-sponsored religion. Okay, England had the Church of England, the Anglican Church. It was a government-sponsored religion. Some colonies said no, can't do it. Okay, can't have an official one. And it prevents government actions that prefer one religion over another. Now, keep in mind, were there multiple religions in the US at this time? Yes. But they were mostly thinking of can't be Anglican over Presbyterian or Methodist over Quakers. They were mostly thinking in the realms of Protestants, maybe Catholicism thrown in there, right? But it did encompass everything here as well. All right. So there's some clear things in the Establishment Clause. What is clear? Okay. You cannot compel someone to go to a religious service. The government cannot compel someone to pay money to a certain religious organization. The government cannot influence the clergy. The government can be like, oh, we need this to be, they have to be the pastor here and they need to be the rabbi here. No, they can't. The government does not do that. Okay. Those things are clear. All right. If you can't give benefits to some and not to all. Some things aren't as clear. Right. That's why it's still debated. That's why people still have questions about this. And over time, SCOTUS has had to clarify some of that. So, example, the government can give aid to certain religions, organizations, but it needs to be neutral. You know, if you're giving aid after natural disaster, but you're not just giving it to one specific religion, you can give aid to a religious school so that they can purchase books to educate the children, but they have to be, say, math books. They can't be the religious books. All right. What about things like government-sponsored prayer? Okay, then some things are more stringent and less stringent than others. They're more stringent about prayer in schools. No, you can't, right? There's no announcement in the morning where we have a prayer after the pledge and the national anthem. Things like that used to happen. It's less stringent for adults, right? We see the House, is it the House, what is their title? The House chaplain giving prayer before House sessions. It's even less stringent after school hours. You can have religious clubs in schools. That's not part of the official mandatory school day, but things that kids choose to join afterwards. What about accommodations for religion? Right? What about religious exemptions? I don't get this vaccine because I have a religious exemption. I don't have to be drafted because I'm a Quaker, and that's religious exemption. What about accommodations? Okay, if you are in jail, it is okay for the prison system to allow you to, in that prison, go to a prayer service, or pray. I mean, technically the government's paying for that prison building, but it's an accommodation so that before they can practice their beliefs. Okay, what about symbols? What symbols are okay for governments to have, like, say, on a building? Does it matter if it's like encouraging this religion? Does it matter if other religions? But what about non-religion? You also can't favor a religion over a non-religion, right? It's why it's okay for some town halls to have a Christmas tree, which is technically, right, connected to religion, even though it's not always really used that way these days. But you might get some heat if you have a manger scene outside, which my town hall does. And it's been a reason for some discussion here. All right. It looks at things like the funding source and all sorts of things. Now, look at Engel v. Vitale. This is one of our required cases. This was New York. This was 1962. And there was a voluntary prayer, I believe it was the beginning of the school day, where you just had to pray. Now, you could be praying to different gods. You didn't have to be the same religion. You said be praying to your higher power. The ACLU sued. So this is now cool. All right. SCOTUS found that it was a violation of the Establishment Clause because it was promoting religion over non-belief. Like, what if you don't believe in anything? Then what do you do? Right. And then this became a precedent, and then a lemon test is often used afterwards to see this. We'll talk about the lemon test in school. I'll give you a little bit of a visual. All right, so now what about the Free Exercise Clause? The Free Exercise Clause reserves the rights of individuals to accept any religious belief and engage in rituals. All right, there's some boundaries there. You can't say my religious ritual is to go around killing people. You can't say it's to go burn down school buildings. All right, but there's the right to break some laws if it fits under this. All right. So let me look at this here. This is Wisconsin v. Yoder. Okay, Wisconsin v. Yoder is another one of our cases, and it had to do with attendance by Amish and Mennonite students. The law said you have to go to school till you're a certain age. And they said no, because once they're in high school, we don't like what they're teaching, and we think it goes against our religious beliefs, and we'd rather have them home. So this is allowing them to break the law by not sending them to school, but it was narrowly tailored. This doesn't mean that just no one can go to school now. Anyone could just say, oh, I'm not going to school, right? Don't try it. Don't try it. You wouldn't want to leave this school anyways, all right? But that is where it comes under strict scrutiny. right? There has to be a compelling state interest for this law to exist. And then it has to be narrowly tailored to fit what that exemption would be so that people can freely exercise their religion. Okay. This is still something that SCOTUS deals with. Right now, this month, they've been looking at Kennedy versus Bremerton School District. You may have heard this case about the coach that was praying at the end of the football games. And does that violate the Establishment Clause? Right? Can he argue free speech? Right? Well, maybe not while you're working. Your employer can still have certain requirements, right? So lots of things at play here. So we'll keep following this and see where it's at. All right. I hope this was a good intro for you guys. We'll talk about this. We'll talk later.